Hi, everybody. We're starting up here. It's top of the hour. I see people jumping in. Really excited to have this event today. My name is Paul Hitchcock, and I'm partners with Harry Barth at Barth Calderon. He's the founder and senior managing partner of Barth Calderon, asset protection, estate planning, and business planning law firm located in Orange County, California. You can see our headquarter office there. Really excited to have Joe Shott here, who is an incredible Vistage Chair out of Pennsylvania, doing some amazing things. So welcome, Harry and Joe.
Thank you,
To be
Paul.
here.
Glad to be
Yeah.
here.
Yeah, and Joe, I want to start with you because we talked about this offline, and then you aligned, with Harry and the firm on this to get information out. But tell us what you're doing there with Vistage and what you're building there.
Yeah, well, I currently have three groups that I'm running. I was actually a Vistage member for almost 18 years. And what it comes down to is it's a group of CEOs and business leaders that come together and help each other work through our problems. We hold each other accountable. It's just a fantastic opportunity to be challenged as the CEO and leader of your company. So yeah, and topics like this, these are the types of things I love learning more about. To
Yep.
have the opportunity to sit with Harry here and discuss this new law that's on the books and how most, if not, I'll tell you, I have not come across anyone that knew about this. I work
Right.
with over 40 different CEOs and none of them heard this. So I'm really excited to bring something like this to them as we learn more.
And Joe, you've got opening seats there for your groups. Who are you looking for?
Yeah, currently, one group is totally full. I have no room, no seats available at this time, but two of my groups do have a seat or two open, and I am, always looking to meet, business owners and just have conversations with them to see if this might make sense for them. So, yes, I do have a couple openings right now.
Great. Okay. Well, Joe, we're going to put your information up in the chat there also for everybody. You're going to hear a lot from Harry, and if you have questions, we're going to have Q&A here with Joe. If you can monitor the Q&A as we go along and just handle that with Harry, that'd be great. And then we'll also give everybody a chance to get one-on-one with Harry and the team afterwards. If you want to go into detail and you got to figure out your own situation, we have a complimentary assessment we're doing for anybody that wants to figure out how this new law impacts them and how it's related to asset protection, which we do here. So with that, I'm going to move it over to Harry. Harry, you want to take it away?
I sure will. Well, good morning, Joe. Good morning, Paul. Good morning, everybody. Uh, Welcome to the most important law that you probably never heard of. So, and that, of course, is an issue. Let's talk a little bit about a couple things, some definitions. You're going to hear me use the term FinCEN quite a bit. FinCEN refers to the Financial Crimes Enforcement Network, who is the division of the United States Department of Treasury that is responsible for the monitoring and enforcement of this new law. The new law, guys and girls, was actually passed in a bipartisan legislation in 2020. However, was not implemented until January 1st of 2024. But I think as we go through it this morning together, and I'm going to get into the weeds and the details for all of you, I think it's important to understand, most important, what this law is all about. Because if you understand what it's about, then what I'm going to say to you is going to make a lot more sense. The law basically was born on 9/11. In 9/11, governments, not only our government, but governments around the world, really concerned about financing of terrorism, money laundering, and front companies and shelf companies that are being used for nefarious activities worldwide. It's actually quite common. And you'll also find that in looking at this, some steps were already taken. There was the Patriot Act, Know Your Client Act. You can't go to a bank and get financing without saying who you are, what you are. You can't get a notary done without a driver's license and putting in your address. So I think that what we're dealing with here is the building, or what the United States government is building, is a private, it's not for public consumption, it's not for anybody to use. It's a private registry of who are the human beings behind the entities. That's very important to understand. Who are the human beings behind the entity? So the whole purpose of the Corporate Transparency Act is to drill down to find out who are the human beings. This is not targeting large companies. This is targeting small, limited liability companies, limited partnerships, limited liability partnerships, and corporations. C corporations, S corporations. Think about it this way. If we need to go to the Secretary of State of Pennsylvania, Joe, and give birth to an LLC in Pennsylvania, it is an entity that is subject to having its information recorded with the Department of Treasury through the Financial Crimes Enforcement Network. Right now, as we sit, trusts, which are not born through the Secretary of State's office, are exempt from the Corporate Transparency Act. There is sister legislation moving through the government to try to kind of bring those in as well. Now, how serious is the government about this? So let's talk about this. This is kind of strange, but there's no law that's like this that's out there. Failure to comply with this law, and we'll talk about the compliance, will result, as of this week, actually, in a $591 a day fine, all right, to a maximum of 30 days, up to $10,000 of a criminal fine, and up to 2 years of imprisonment. So it's a felony not to comply with this law. So if you willfully say, hey, we're not doing it, then you risk really going to jail. And it's the same people that are monitoring foreign bank accounts, FinCEN, are the same people that are responsible for the Corporate Transparency Act. So we begin a little bit with, and understand there's a couple things. There is a legislation moving through that was passed by the House, not yet passed by the Senate, and not yet signed by Joe, that extends some of the deadlines that we're going to tell you about today, but it's not yet law. So we're going to tell you about the deadlines as they appear today. And there's another case, the National Small Business Association of America has a case which is challenging the constitutional validity of this law on a number of different fronts, which is working its way through the federal system. Now, I have almost 50 years of experience in this area, and my humble opinion is that the vast majority of the Corporate Transparency Act will be held constitutional, but some aspects of it may not. One of the things is, it's putting a burden on every single entity, not new ones only, but everyone that's in existence. 33 million of them need to comply, and every new one needs to comply. There's a tremendous burden on the business community to comply with this law. There are tremendous criminal penalties for not compliance with this law. There are the areas of uncertainty about this law. When you add all of that up, it kind of says, well, we're trying to comply with a law that nobody knows about, and it's criminal not to. And in the end, will this really curtail terrorist financing and money laundering and other things? As we go through it together, we'll decide today whether we think that will work or not. But that's the challenge to it. I don't think the challenge is going to be successful. Most of the Western economies, Britain, France, Germany, others, and modern Asian economy already have this in effect. Notaries are already in effect. Know your client rules are already in effect. So having this registry of all entities in the United States of America, which is available allegedly only for law enforcement purposes, I think it's going to be here to stay, and going to be here to stay for a while. Okay. So we started by saying that LLCs, limited partnerships, corporations are all subject to this rule unless they are exempt. All right. So there are about 23 some odd exemptions that are available. And if you fall into one of these exemptions, you do not need to comply with the Corporate Transparency Act. So let's talk about what they are. Public companies do not need to comply with the corporate, because they're all, everyone's examined them. The SEC's examined them. FINRA's examined them. The stock exchanges examined them. They've had a bunch of filings. We know who the people are. It's all public. So they're exempt. Certain SEC registered investment advisory firms, which are regulated by the SEC, are exempt. So if you own a registered investment advisory firm, you're already regulated to death, so you don't need to comply. Venture capital fund advisors are also regulated and do not need to comply. Insurance companies are regulated and insurance producers are regulated, so they are exempt from this act. Certain highly regulated financial companies like banks, credit unions, and registered securities broker-dealers are all highly regulated. Everybody knows who they are. They're exempt. And trust companies usually fall within that highly regulated area, so they don't need to comply. Public accounting firms, CPA firms that are registered to be able to do public audits for companies under Sarbanes-Oxley are exempt because we know who they are too. Tax exempt entities like nonprofit organizations, are exempt. Political organizations are exempt. And subsidiaries, this is very important, wholly owned subsidiaries of exempt entities are exempt. So if the parent is exempt, a wholly owned subsidiary is exempt as well. And the one exemption that applies to most of your Vistage members and many we'll talk about, and these are ands, not ors. If the company has over 20 full-time employees as defined by state law, has its headquarters in the United States of America, and has over $5 million of gross sales under current law, it is exempt from filing. So talk about that. So I was thinking about that a little bit, and you and I were talking about it earlier on, Joe. So I own a law firm. My law firm has over 20 employees, we're over $5 million of gross sales, and our headquarters are in the United States of America. My law firm is exempt. But Harry has 12 LLCs and limited partnerships that I formed over the years that hold real estate, securities, and other things that I've done for estate planning and asset protection purposes. Every one of those need to be filed. Many of your members will have to do manufacturing, but the building that they're working in is owned by an LLC, which leases to the manufacturing operation. That building, that LLC, which is owned by the owners, in a separate entity, needs to file. So there's an awful lot of compliance that needs to take place. So many of us may have a business that may be big enough to be exempt from the act, but the vast majority of us will be touched by the Corporate Transparency Act.
Harry, that's something key that I was just thinking about. Most Vistage member type size companies do own property. They own their own building, their own warehouse. And
sometimes they own equipment too that they lease, or they own intellectual property or other. Great asset protection, not to keep all the eggs in one basket. We do that all the time as attorneys for our clients and protecting them. Not all thine eggs in one basket. You have valuable IP, you put it in a separate LLC and license it to OPCO. Mm-hmm. So the answer to that is absolutely. So all of those are filing.
Need to be thinking about it.
Well, it's more than need to think about it. We have to comply. This is not a think about anymore. So let's do a dividing line as far as that's concerned. Let's talk about, there are slightly different rules. Let's talk about a new entity that was formed after January 1st, 2024. And then you have all of the existing entities that were formed before January 1st, 2024. There are no time limits. If you formed it 50 years ago, it still needs to comply. All right?
34 million or something of them, Harry?
33 million. Well, 33 million that need to, that are complying entities, which will break up and wind up at about 150 million or more beneficial owners. So let's talk about timelines. So for all entities that were in existence prior to January 1st, 2024, under the current law, they need to be in compliance no later, believe it or not, Joe, by December 31st, 2024. 11 months from now, 33 million businesses need to be registered under the Corporate Transparency Act with FinCEN. Wow. The bill that's moving through Congress that's not yet passed will extend that for a year. So they have until December 31st, 2025 to be in compliance. But what we'll do is we will we'll analyze together a new entity that was formed after January 1st, 2024, because when we understand what happens there, then it'll be easy to apply it to all of our pre-existing entities. So for a new entity that's born after January 1st, 2024, we have 90 days from the date that the Secretary of State says go, okay? You file it, in Pennsylvania or wherever we file it in Pennsylvania, Secretary of State says, your entity is now formed. We have 90 days to bring it into compliance with the CTA Act, or 591-day penalties, dollars a day begins to file, and if it's willful, it's criminal. So what we're going to do is we're going to form a new company. We'll call it Joe, Paul, Harry Co. LLC, and we'll file it in, doesn't matter, we'll file it in Delaware, authorize it to do business in Pennsylvania, and away we go. And we file it today. So now what has to happen? So the first thing we have to understand is that in all probability, this is not an exempt entity. So it's a filing or reporting entity. So what has to be reported? And by the way, all reporting is electronic. There's no other way to report other than electronically through the FinCEN website. You will learn that we are, for example, for us, we have a service that does all the filings because you don't want to sit there and do them yourselves in that Byzantine website, and a service that does the analysis. And we'll talk about that in a little while. So we decide that we're going to form our company. A company is also going to be known, have a DBA as Widgets Are Us, and we're going to manufacture widgets. And so we get it formed, we get the okay from the Secretary of State, and away we go. So now that we are a entity that is required to file, let's talk about the first thing. The responsibility for filing is the responsibility of the entity. So Joe, Paul, Harry Co. LLC is the entity that's responsible for filing. So the first step is we need to go to FinCEN and tell them, this is the name of our company. It is Joe, Paul, Harry Co. LLC. We must also give them all of the DBAs. All right. So we have a DBA as Widgets Are Us. All of that. So that information has to go to FinCEN. We must give them the physical address of our company, not a UPS suite, not a post office box, not the lawyer's office, not the CPA's office, our company office. We must give them that. And we must give them a specific identifying, government-issued identifying number for our company. So the identifying number for our company would be the EIN number that we applied for with the IRS. Now, that has to go as well. If we don't have an EIN number, we have to get an EIN number. For many people who use single member LLCs, which were known as disregarded entities, they don't get a EIN number because it doesn't exist for tax purposes. Then their social security number must be given on behalf of that entity, or they get a taxpayer identifying number as a matter of convenience for that particular entity. So that is what we need to do for the entity to start. So now we have Joe, Paul, Harry Co. LLC. Now, the next thing that happens after January 1st, 2024, but not for prior entities, we also must disclose who, believe it or not, who is the paralegal or who filed this thing with the state of Pennsylvania, known as the company applicant. So the paralegal in my office, for example, needs to say that I filed these documents on behalf of the company. All right. And then if I'm the attorney that recommended this LLC to us, I also must file as a company applicant. So Harry Barth, FinCEN number, Cheyenne Petty, one of my paralegals, FinCEN number are the company applicants. All right. We don't have to do that for pre-existing entities. We have to do that moving forward. I keep talking about company FinCEN numbers. So let me just pause for a quick second here about that. You can go, Joe, to the FinCEN website. Paul will be posting it later as a link in the chat. And you can set up an account with FinCEN, and should. That account basically says, hey, I'm Joe Shott. Here's my address, and here's my a color copy of my driver's license in the form of a PDF or my unexpired passport. When you do that, they will give you a number 1, 2, 3, 4, 5, 6, and you'll always be known as Joe Shott, number 1, 2, 3, 4, 5, 6 for FinCEN and CTA purposes. It's easier than every time having to put down your home address and these credentials every single time you are required to report. So I got a FinCEN number. We would normally do that for our clients. We can't, because in setting up that account, they want to, we had to go to elementary school, what was the color of your first pet, and two-factor authentication, typical government Byzantine, but security. But I'm glad that they're doing it. You get that number, then you'll give it to whomever's doing your analysis and doing your filing for you, should you not do it yourself. Okay. So now we have the company itself, all right? And now we have the company applicants that formed it. And now we first begin. So now what we need to report to FinCEN, remember what they're after. Who are the people behind the veil? So what's the next thing we need to do? All beneficial owners of over 25% of our entity need to file as the beneficial owner of the company. So in our company, we got Joe, we got Paul, we got Harry, a third. So each of us are beneficial owners of over a third. We must report that we are the beneficial owners. All right. And so what is that reporting? Joe, it'll be your name. It'll be your full legal name. It'll be your address. And it'll be a color copy of your driver's license or passport to show that you're the real human being that owns 1/3 of that. If you have a FinCEN number, your 1/3 would be Joe Shott, number so-and-so, so-and-so. Okay. So we have to do that for all of the beneficial owners, if of over 25%. If we have a minor who is an owner of 25% or more, they do not have to report, but their parents need to report. Interesting if the parents are divorced and not talking to each other, but they must report. There are no exceptions to the law. When the minor reaches age 18, they have 30 days to report, and the parents come off and the minor comes on. So if Harry gets hit by a bolt of lightning, and now my 1/3 is being passed by my living revocable trust, or being passed through a probate process or a surrogate court process, as soon as that my 1/3 lands at someplace else, all right, they need to report. All right. Now, that may be fine, but you see, the legislation is a little weird. It's weird because it says all beneficial owners must report, but the legislation doesn't really say that. It says all beneficial owners and all people in control of the entity need to report. So that means in our LLC, if we are the managers of the LLC, we're now reporting again that Joe, Paul, and Harry are the managers of the LLC. If we're a limited partnership, our general partner needs to report. All right. So let's say we were an LLC and we elected to have a corporation manage our LLC for us, controlled, managed. Now that manager must report. Anyone that has control has to report. So now who needs to report in that corporation? All of the C-suite people, the CEO, the COO, the CFO, the CIO, the CTO, anyone that has control of that corporation, that has control of our LLC, needs to report individually to FinCEN. If the board of directors of that corporation has the ability to remove or replace any of the C-suite members, the board can fire the CEO and bring in a new CEO, then the board must report on behalf of that as well. That is a very interesting component because you can have a voting trust. You can have a power of appointment. You can have many, many different aspects of that. You can have voting and non-voting shares. You have 99% voting shares in a company or 99% non-voting shares, for example, in an LLC, and 1% voting, that 1% voting needs to report. They're not at 25, but they're controlling. They need to report. I'll give you an example of that. Sure.
I have a question here. So I understand the complexity if you have a company managing the LLC.
Yeah.
What if you hire just a director to come in and run your business for you, and you're not involved? They're the decision maker. Do they need to be registered, even though they're not an owner?
Yeah. Well, matter of fact, all of the doesn't matter whether they're an owner or not. If they have control, they need to report.
So what defines control? Is that defined?
Yeah, it's defined by saying, do you have control? Can you make a decision that impacts the company? Remember what they're looking for. Can you move a piece of property around? Can you change a piece of property into money? Can you distribute money from they're looking, who are the human beings? If you have something that they don't know who it doesn't work. Every single human being that touches that company must report. And it's the obligation of our company, of Joe, Paul, Harry Co., to make sure that those individuals, first we got to figure out who the hell they are. All right. And then once we figure out who the hell they are, we have an obligation to have them report. And if our guy that we want to put in charge doesn't want to report, then he cannot be in charge, which gets me to my next point. So I'm going to get back to that in a minute because it's a very important component. Let me give you an example. We were talking to Vistage Chair of the day, and it was in Texas. And everybody in Texas, as we all know, they're in the oil business. All right. So he has a lot of members who are in the oil business. So he says, all right, let me walk you through a typical structure in the oil business here in Texas. And Harry, you tell me how this is impacted by the CTA. He says, now, normally when they drill a well, it's done by an LLC. No, because if the well blows out or has problems or starts on fire, nobody wants personal liability. Absolutely. Of course, it's an asset protection attorney. We want it that way too. So we have that. So the oil well, the oil well is now that LLC is now a reporting entity. So we have to give the information on the entity. We got that. Typically, the 4 members, they have like 4 investors that went into the oil well to invest in that oil well. And those 4 investors, each one of them is an LLC. So each one of those LLCs is a reporting entity. Now, Joe, if your LLC is part of the reporting entity in the bigger oil well, and typically you met with me and we did an estate plan, you have a living revocable trust or a generational or a dynastic skipping trust for children, whatever it may be, you have that LLC owned by a trust. Now, trusts themselves are not reporting entities. But if a trust owns a reporting entity, then we have to look into the trust. So you put your 25% interest in the oil well into the Shott family trust. Now we need to look into that trust. Who are the trustees? They need to report. Who is the settler who has the ability to move assets in and out of the trust? They need to report. If there's a trust protector, they need to report. Who are the beneficial owners? Who are the beneficiaries of the trust? They need to report. So all of a sudden, we have this, or it's held by a holding company, but 25% is held by a bigger holding company that invests in all these wells. The big holding company needs to, although the big holding company itself doesn't need to report, it needs to report its ownership interest in our oil well in your LLC. In this one scenario that I just put together for you, we can have close to 40 or 50 reporting people on this one entity in order to be in compliance. And we have 90 days from the day that it's born to figure all of that out. Now,
90 days for the companies that have just been started this year.
Yes.
Yes. Harry, before I don't want to miss this. We have a question because it's related to the control. The question is, does a property manager need to register?
If the property manager is an entity, the answer is yes. If it doesn't meet one of the exceptions, of course they do. If it's an individual property manager, all right, that's not an entity, and but they have control of something of the underlying. See, you can have a property manager that gets a fee to manage the property, but they don't have control of the LLC or of that it has the property. Probably not. But if they have control, then the answer is 100% yes. Remember what I said. We want to know if it's Blue Sky Trust doesn't do any good. They want to know who's the Blue Sky Trust. Think of the Pandora Papers. Think of the Panama Papers. Think of all these people hiding. I think Mr. Biden has 18 shell LLCs that have all kinds of money floating around in it. Nothing. That doesn't mean it's nefarious. They want to know who's behind all. I think just the other day, a Google guy owned the 5 islands off the coast of Puerto Rico in various different LLCs that nobody knew he owned. All right, at all. But that's the way that they're drilling down who owns it. Because is it being used to finance terrorists and money launder, evade taxes? And that it's so that's the purpose of this that's being done.
Yeah. Well, you said who owns it and who controls it.
Yes.
Those
Who
two are
owns it
important.
and controls it? You can have a scenario where you and I, Joe, we have an LLC that has 10 owners, each one at 10%. No one, and we have a reporting entity. Our LLC needs to report, but none of the beneficial owners need to report because none one has 25%. But the 1 or 2 people or 3 people that control our entity, all right, maybe you and me, we definitely need to report. And if we have it in our trust needs to report all that information. And remember, some of the trusts that have been designed by people like myself, they're complicated. All right. They have trusts, there are sub-trusts, there are different trusts, there are irrevocable trusts, revocable trusts, that are used for asset protection trusts, dynasty trusts, generation skipping trusts. All of these various different tools, we need to know who the human beings are behind it. Now, in the legislation that's running through Congress right now, remember I said there right now a change. All right. If there's a change, if we go from a 17-year-old becomes 18-year-old who's a 25% owner, under the current law, it changes. We have 30 days to report. So if you are living in Pennsylvania and now you move to New Jersey and you get a New Jersey driver's license, New Jersey address, you got 30 days to report that. The company has to ensure that all of the reporting parties are up to date with FinCEN. It's a company responsibility. This is going to be really challenging when it's held by, sometimes in the older companies, may be held by a trust that's 40 years old. Half the time you don't know who the trustees are, and sometimes they may not be talking to each other, and they have to be in compliance. But in the new law that extends that 30 days to 90 days to report a change and changes December 24th to December 25th, okay, that gives us an extra year for the pre-existing entities. There's another part that's quite draconian. And the other part is there's an instruction under the law from Congress to FinCEN, the Financial Crimes Enforcement Network, that there can be no exceptions, none. If you say, well, we can't get Joe Blow, one of our 25% owners, to report, FinCEN has been instructed not to accept our filing. We will be out of compliance and we will be subject to a fine. We got to get rid of Joe Blow, or he needs to comply, or he or she needs to comply. There are no exceptions. And that's going to be challenging with divorces and intergenerational transfers. I don't quite know how they're going to do it, but it also leads to some of my aspect of the constitutionality of that part. But right now, that is the current law. So, which leads us to believe, what else do we need to do? Well, think about this. We probably, in every new entity that we form, and we form, sometimes 60, 70 entities a month for our clients, we have new sections of the operating agreement. The operating agreement with an LLC, CTA, Corporate Transparency Act. You, as a member, will comply with the law. You sign to that. If you do not comply with the law, the company will buy back your membership at 1/2 book value. Good luck, accept it. So you need to comply. We need to put a compliance factor in. So we now have to bake into new operating agreements, new limited partnership agreements, new corporate shareholder agreements language relating to compliance with the Corporate Transparency Act. Now that gives us an opportunity, or gives everybody, your members, an opportunity to do a little inventory, a little housekeeping about all their agreements. Those agreements have kind of been out of whack for a long time in many, many cases. And if we got a bad actor that's involved, and maybe an owner, it's a good time to maybe try to get rid of them because they have to comply. It's just a great time to do some housekeeping and make sure that the stuff is right, because we have to look at it anyway. But
Is that
we
the
have
same
to.
with buy-sell agreements, Harry?
No, not really. A buy-sell agreement. No, it'd be more, the documents would be more shareholders agreements, limited partnership agreements, and operating agreements, not the buy-sell. That would be involved with that. And so that's kind of really important in the formation of our new entity. Now, when you do a new entity, we kind of know, as the attorneys, and again, this is not an advertisement for lawyers, all right? But let me give you a couple things. The AICPA is the organization that deals with certified public accountants, have told their members not to go near helping people with the CTA because they consider it to be the unauthorized practice of law. Dealing with, like you said, who is in control? How the degree of control, the nature of who controls a trust, and all of the arcane members of a trust, the determination of beneficial ownership. This is law. All right. So, and since there are criminal penalties associated with failure to get it right, if you should be doing this under attorney-client privilege. So, for example, this is just an example of our firm. We're charging like $595 to analyze an entity and get all of its stuff, and $250 to file it. So you don't have to sit there and enter 60 different people to comply with the act. Our team will do that. Of course, you would have to get your own FinCEN number if you wish to go in that particular direction. So that's what has to happen with new entities. Now, new entities are interesting. People asked about ESOPs. What if my business is owned by an ESOP? Well, a couple things. Usually, most of the time, if you're going to have an ESOP, usually it's over 20 employees and over 5 million in sales. If it's smaller than that, then the ESOP does need to report. All right, because it's an owner. It's an owner of over 25%. And then in the ESOP, you usually have the controlling person who is the current owner of the business. Then you have an ESOP trustee that represents the ESOP. They would also need to report. And if we have corporate trustees, they're not interested, like you said, Bank of America is a regulated institution in a trust company. They don't need to report. But if Bank of America owns over 20, as a trustee, has over 25% ownership interest in our entity, then the trustees that have the ability to make a decision in there need to report. The trustees, the Bank of America employee needs to report their name and their FinCEN number. There is argument going on right now in FinCEN as to whether or not institutional, highly regulated trustees need to report. But as we sit today, they do need to report. Okay. So we have many of our trustees that we use in Nevada for Nevada Asset Protection Trust. If there are 5 trustees that can work on that account, those 5 trustees need to report. When we are doing international asset protection trusts, Cook Island trusts, or trusts that are offshore, if they are reaching in, those trustees, they need to report. And they're reticent to report because they're not, but if they're going to own a U.S. company, and if you have a foreign LLC, a Nevis LLC, a Cook Island LLC, a Barbados LLC, a BVI LLC, as many of your members might have for certain types of things, or for insurance companies, for example, for a captive insurance company in Bermuda that's doing business here in the United States, that captive insurance company, unless it's over 20 employees and 5 million, which usually they're not, even though it's foreign, the fact that they reach in the United States, they need to report.
Okay.
So
Harry, we have another question here.
Well, I think we're almost ready to do all the Q&As. So let me just get to, go ahead.
This is regarding trusts, so I thought it would be a good time to ask. It says, regarding trusts, do cash balance and profit sharing trusts need to file?
Well, that's a very, very good question. The trust itself is not a reporting entity. But now the question is, if the trust, well, let me answer this more succinctly. If the pension trust owns a more than 25% or more of an underlying reporting entity, which is very rare, by the way. It's usually the GM stock and John Hancock stock and IBM stock. Rarely will a pension be authorized to own a tiny small company. Then it would need to report. But it's very, very rare. The pension trust itself doesn't need to report. It only needs to report if it owns a reporting entity or 25% or more of a reporting entity. And that'd be very, very, very rare for a pension plan.
Okay.
But the answer is yeah. Yeah, they're I gave you the 23 exemptions, but those exemptions are kind of weird if they begin to now own reporting entities along the way. They themselves may be exempt, but they own it, then they become a beneficial owner, and that beneficial owner does need to report. Hallelujah. And so we have those aspects. Let's talk just for a second, because I beat to death new entities. Let's talk about the older entities. So 33 million of them. Well, everything that I just talked to you about applies to them. Has to be filed as under current law by December 31st, 2024, or the penalties begin. And only thing that does not have to be filed on the older entities is who the company applicants, who is the attorney that formed it, or the paralegal, or doing, if people did something at LegalZoom, for example, LegalZoom forms it. And so you go over to LegalZoom, Joe, and do an LLC. You are the one that filed it with LegalZoom, files it with the Secretary of State's office. So they are the company applicant. LegalZoom does need to report that they filed that on your behalf. So you bet they do.
So Harry, I'm curious. You formed formed an LLC like 20 years ago. I have no idea who formed it. If I did it, if I had.
Yeah, prior to January 1st, Joe, 2024, we don't need the company applicant.
So we don't need. Okay.
No, we don't. It's only for new entities formed after January 1st, 2024 that we need to do that. The other thing we also need to be concerned about is data privacy. A lot of data is going to be flying around the country. Sensitive data. Joe, where you live, Joe, your address, Joe, perhaps your social security number, Joe, a copy of your driver's license. Got to make sure that as that's moving around between law firms, government websites, that it's encrypted and we have the protection for the data, because for bad actors, this is going to be a boon to try to grab that data while it's in transit. So we have to be concerned about the way in which it's going to be transmitted. So let's talk for a second before we go to Q&As. I think you kind of got the picture. The company needs to report, the beneficial owners need to report, and that would implicate trusts, holding companies, voting trust. Even in a trust, someone that holds what we call a power of appointment, they need to report. Anyone that has control over a disposition of an asset in a filing entity must report. And the penalties, for example, the penalties, up until a week ago, the penalty was $500 a day. And literally just this week, FinCEN adjusted it for inflation to $591 a day.
I was wondering how they got to $591.
They took the inflation rate and adjusted the penalty at $591 a day. They're dead serious about this, and so let me just wax poetic for a second, and then we'll go to Q&A. So poetically, one of the hallmarks that are being argued on the constitutionality of this legislation is the benefit versus the burden. So look at the burden that was just myself alone, and you, with our entities, our pre-existing entities. It's a burden. Now, for everybody to know, it's one and done. Once we get it filed with FinCEN, we don't have to touch it again, absent changes. If there's changes in anything, change in control, change in ownership, which happens all the time, we have 30 days to bring that in so we don't go out of compliance. But it's one and done. It's not an annual filing that has to take place. So that is somewhat helpful. but there's a burden on 33 million legal quality small businesses, persons whose spouse runs a hair salon, somebody who's at a barber shop. There's no exceptions for these. It's targeted for the small companies because that barber shop could be laundering money. These are the things that they're after. And you're going to have that burden. It's going to be a cost, even though there's no cost to file with FinCEN. There's going to be a cost to have your entity analyzed and structured properly. We have to charge a little bit more now for an LLC or a limited partnership or a corporation because we now have to add all that stuff and get everything filed on your behalf with FinCEN. So you're going to have a cost for analysis. You're going to have a cost for filing on businesses that are already burdened with cost. And there has to be a benefit. Now, the benefit is noble. All right. The noble benefit is to keep the bad actors away from our entities. Still, if you form a Wyoming entity, it's still private. It's private. You still don't know who the members are, the managers are. This is not a public registry at all, but it can be shared with the UK. The UK government could share their information with the US if they're looking for a nefarious activity. The trouble, in my estimation, is that the bad actors are going to find a way around it anyway. They'll fabricate names, they'll fabricate stuff, they'll have fake driver's licenses, and God knows what they'll have. So they're not going to stop the bad actors. It's like you take the guns away from good people, and the bad people, they don't care. They get guns illegally. So the bad people, this may make it a little bit more difficult for bad people, for cartels and terrorists to use entities in the good old US of A for illicit activities with front and shell companies. But I think they're going to find a way around it. But we get the burden. So, but that's just one man's opinion. So we need to go to questions now because we only have about 10 minutes left, and we do need to stop at the top of the hour.
Okay,
So
well,
let's do questions.
Yep, we have a few here. So if a person is an owner and controller, does that person need to get two FinCEN numbers?
No, it's one FinCEN number, but reported in the two positions.
Right. Okay.
So owner, Joe Shott, controller, Joe Shott, number. Yes.
Right. Okay. Next question is how is this different from an annual statement of information with the SOS?
Very different in that, first of all, it's not going to the Secretary of State. It's going to the Department of Treasury, to the Financial Crimes Enforcement Network. In the SOS statements, for example, use a Secretary of State's office with Wyoming. Members and managers are not necessarily disclosed where you live. You don't need to have your driver's license or passport. All of that information is needed for CTA, but it's not an annual filing. The annual reports are annual. This is just one time to get it registered. We want to know, again, started the first thing I said, who are the people that are involved between Joe, Paul, Harry Co. LLC. It might be JPH LLC. Who is J, who PA, who's the owners, and who can move money around? That needs to be registered. And once it's registered, they're happy.
Yeah. Well, it goes back to the intent of it. The intent is good. The question is it really going to achieve what with all this work, achieve what we want?
I don't know if it will or it won't, but I do know that they're serious about the penalties.
Yeah.
They're very serious. Clearly. It's a felony,
Yeah.
We bumped into this with people who have failed to file foreign bank account reports.
Yeah.
They have actually fined the hell out of them.
Yeah. All right. Let me get to this question here. Pre-2024 entities, ones that have established before then. If we dissolve a reporting entity or remove some controlling individuals, is reporting needed before the end of this year?
No, it's the status of the company at the time that you report. So if the company is dissolved and doesn't exist by the end of 2024, doesn't have to be reported. If we had a controlling individual who's there now, who's not there at the end of the year, at the time that we report, we need to have the controlling people. And then if the controlling people change, then we have 30 days to file that with FinCEN. So we have to make sure that our reporting companies, this is important, have a procedure in place for dealing with the changes to CTA so the company is not in willful violation of the CTA Act. So once we have it set, we're fine. But we, Joe, Paul, Harry Co., we have the obligation that if we're going to bring in a member, or if there's a change, or we change the controlling people, that they have reported to FinCEN. So that's important that we have that in place.
Okay. So in regard to FinCEN and companies and owners, I clarify, the question is the FinCEN number for the company, or do each owner need to get their own
Okay,
FinCEN?
there will be no FinCEN number for the company. The company will just give its name, its address, and its identifying number, EIN number, or social security number for disregarded entity. The FinCEN number is for all the individuals that are involved. The beneficial owners, the controllers, trustees, trust protectors, settlers, beneficiaries, all the people, okay, get a FinCEN number. Now, you don't have to get a FinCEN number, but every time I got to give your home address, and your driver's license, like a notary book. If once you have a number, you just got to keep that information up to date with FinCEN, and it becomes a lot simpler for those of us that are reporting on your behalf. Just to put in, it's Joe Shott, number so-and-so, so-and-so.
Yeah, and a couple things is, I just want to mention that I did put up the FinCEN site URL there in the chat. So that's where you go to FinCEN. That's their official site there. The other link I put up there is if you want to get information on, having us help you understand if you're impacted and file for you. That link is up there in the chat. And then Joe, I just want to make sure you saw there's a Q&A there outside of the chat if you want to pick that one up.
Yeah, we have another question. Can you confirm if a married couple owns an entity and one is 75% and the other is 25, does this filing by the main owner with showing both owners mean that only one filing is needed?
No. Actually, there's two questions to that. If married 75-25, we have two owners, 175, 125. They both need to file. All right, that's number one. And number two, in community property states, a husband and wife both need to file because they're deemed owners. So, and then there's family attribution rules where wife may own 10% and husband own 90%. They deem it together. So they both need to file.
Okay. So Paul, there's someone with a hand raised. I don't know.
Oh, okay. Oh, yeah. All right. So I allowed to talk? Mohammed, if you want to ask a question, I think you can talk now.
You're on mute though. No.
Okay.
Nope, there. You there, Mohammed?
Mohammed, yeah.
Yes, I'm here, but you answered my questions.
Okay. All right. Thank you. Yeah. Well, yeah. What do you think, Joe? We got any more? Are we good?
Well, I don't see any other question. I have a question though.
Sure.
Barry, is I agree with the intent here. I like the intent, but it feels like this huge overreach to all the businesses.
Yeah.
And the fact is that it seems like you feel that it's definitely going to, they're going to push back, but we're going to end up having to report.
I think the vast majority of it will stay. I mean, you can't buy a piece of gum without a notary, and that requires the same information.
Right. So my question would be, for entities that were formed prior to this year, should we wait before we go through all this?
It's a great question. And my answer for that is maybe. So we have an awful lot of clients are saying, let's get it out of the way. And they're filing now and bringing it, nothing to hide, bring it up to speed. We'll get it done. I mean, the government kind of knows it has your tax return. They know a lot about you already. They're the ones that issued the passport. They're the ones that issued the driver's license. It's just they're building a registry. So a lot of people are doing it. Other people are waiting. So if you're saying, okay, are we going to get, the main reason they're waiting is to see if we're going to get more time, and then to see whether or not the whole law gets thrown out as unconstitutional. My opinion, just my humble opinion, is the whole law is not going out the window. It's not going to happen. Some aspects of it maybe tone down this criminality associated with it. My God, I could see, I mean, if we don't file a tax return, my God, it's a civil penalty. They don't put you in jail. I mean, to put you in jail, here, of course, the word is willful. In other words, I know I should, but I'm not. You can go to jail. That's the new law. I know I should, or I know I can't, or I haven't complied in time. That's the $591 a day civil penalty. So there's civil penalties and criminal penalties. Criminal penalties are always for willful activity.
Okay. All right. Thank you.
And if that's it, then any other questions? If not, we are ready to go.
Okay, I have one question just popped over. Let's see. Based on what Harry just said, is there a reason I should wait to file?
I don't see any reason to wait. Just, file it, get it done. I don't think there's anything nefarious about it. Now, of course, here's an issue. On some cases, guys and girls, it's really simple. You form an LLC, it's a disregarded LLC, you have it in your trust, you're the manager, you're the one owner. It's relatively simple to file. But in cases where I have an oil well that's in existence, or a business in existence, and 5 parent sister entities, you're talking about not a small amount of money necessary to analyze everything, get it right, and get it filed. If you're using an outside law firm to get it done, like I said, we do $595 an entity and $250 to file it. But I think it's going to be about the price range for professionals to help you do this. So you have a cost. So you want to wait a while to see if we get an extra year, see whether the legislation goes through. For some people, that's a decision that they make. There's no right or wrong answer to that.
Yeah. Yeah.
The deadlines, and that's what they are.
Could be a mad rush at the end if you wait.
Yes, could be.
With the
And you risk forgetting about it too.
Oh, no kidding.
The last question here, I think we're down to the end here. What is safeguarding this? I'll tell you, one of my members who has a cybersecurity company would love this question. What is safeguarding this information from becoming public?
Okay, so you got a couple things. So one of the things that was built into the law is the safeguarding of the information. There are very, very severe criminal penalties for the improper use of the data that the government has. But it's just like, the guy who just released Trump's tax return got 5 years in jail for doing that. So I think that it's similar. There will be penalties enforced on the other side to safeguard and protect the data. But we all know how that goes. With hackers and stuff. Data is data. I hope they'll keep it safe. It's not for public use.
Yeah. Well, it's as safe as it can be, I guess, with the intent.
Yes.
Protect it. Paul, I don't know how we're doing on time here. I got another question.
One more.
Last one. Let's say one more.
Last one more.
Okay. So trusts that own entities are the only ones that need to file with both trustees and beneficiaries filing.
That's correct. That own reporting entities, 25% or more. Correct.
Okay.
Great.
Okay, guys.
Yeah, excellent. Harry, thank you. Joe, thanks a lot. Thanks everybody for being here. And we're going to get the replay out to everybody that signed up. So look for that in your email and love it. Great stuff.
Awesome.
Okay.
Harry,
So Joe, you now know, huh?
I now know. I don't know that I did want to know, but I want to know.
You
I
now
got a
know.
lot to talk about in my groups. I got to tell you, there's a lot
Okay.
of good information.
Well, we're available to help you do that too.
Well, thank you.
All right, Joe. Take good care. Paul, thank you.
Thanks.
Bye-bye.
All right. Yeah.